Hello, welcome back to the Paralegal training. This is your facilitator and your tutor, Dr. Tulipo Mwenifumbo. Uh, Today we are looking at paralegals as community trainers. So when we talk about paralegals as community trainers, we mean that paralegals are there to train the community in matters of the law and matters of development. So we are going to look at two sections. Number one, we are going to look at the theories of legal approach, and then we are going to look at training approaches. In theories of legal approach, I want us to know that there are two. Um, Paralegals give social realities of developing trainings that are more relevant in the framework of law and development in the communities. There are two approaches that or two theories that are there in community training on legal matters. The first approach is called the legal needs approach, and the second approach is the law and development approach. So we are going to look at these two approaches. The legal needs approach. This approach views law as being adequate for everyone if only it is made more accessible. It assumes that there is simply a need for more lawyers, which is not being met because of economical, geographical, social, or psychological barriers. The remedy then is to provide legal assistance to individuals who cannot afford lawyers, hence the need for training. Um, so in this approach, it talks about for us to achieve justice. The approach views that law is adequate. Law is adequate. The only challenge that we have is that we have got few lawyers, and the lawyers are limited to geographical areas and also economical areas. Hence, people don't receive justice as they are supposed to receive because of these factors. So hence there must be a need for the community to be taught and the community to be aware and understand the law. So this is a situation whereby people are able to represent themselves in the matters of law without the lawyers being available. So that is the approach which is called the legal needs approach. So when we train the community to understand and to know the matters of law, people will be aware and will understand their rights. They will know their legal rights and they'll be able to represent themselves. This Paralegals works as social service agencies, traditional legal aid organizations, and other organized bar. The belief being that such legal assistance should function much like the private law firms. So this approach also encourages that the paralegals must operate like a law firm in a community. They must be able to handle the matters in the community that needs to be handled. It also emphasizes of paralegal services is given to individuals in need of legal assistance, educating and sensitizing communities on legal and human rights. So that is what this which is called legal approach. It emphasizes that the community should be sensitized about their legal and human rights. Then the other thing is that this is done with the aim of to helping people to avoid common legal pitfalls in their daily lives. So when the community understand their laws and they understand the law, it also helps them to it helps them to avoid common legal pitfalls in their daily lives. You know, there are sometimes people want to think they are doing a right thing, especially in the instances of the landlords, the tenants, with some leaders, community leaders, and many more. So when people understand the law in the community, when they are educated with the awareness of law, then people will avoid the pitfall, will avoid doing something that is illegal. Same like when you look at the some of the issues that are happening in the community, like wife battering and all those things, gender-based violence. Sometimes it is lack of knowledge, without understanding the legal implications on those matters. And remember that. And uh, ignorance of law is not a defense. So people must be aware. So that when the paralegals in this approach, it tells that when the law is adequate, what is just needed to be done is to make the law aware, or make the communities aware about their legal rights and human rights. So the efforts to make known the formal rights is guaranteed under the law, whether through pamphlets, lectures, or seminars. So this is the approach, which is the legal needs approach. So what is needed is that people should have understanding of the law. The other thing is that the law and development approach. When you talk about the law and development approach, this approach rejects the assumption that law is adequate for everyone, that all that is needed is for law to be made more accessible to those who cannot afford legal costs, and for people to be made aware of their rights. So in this approach, they say no, the they reject that the law is adequate. Why they say that the law is adequate? It does not provide, it has left some gaps. For example, when you talk about the work of the paralegal counselor, is not, the paralegal cannot represent somebody in court. So that makes the law to be inadequate on that matter, because there are people that will need somebody to stand for them in court, but the paralegal is not allowed. So they say that the law is not adequate, and because of that, it should be made more accessible. And as the government of Zambia is trying to do that by providing legal aid to the community. Still now, even if it provides legal aid to the people that cannot afford legal fees, still the cost is very high. Instead, law is considered in relation to the law it plays in the distribution of wealthy power and increasing inequality, as well as in terms of potential of using law to fight injustice. So when you look at in this approach, it is the approach that looks at those people that have got money. They will be able to, they are advantaged in the legal fraternal. Why? Because they are able to hire the lawyer, they are able to use the money to work out whatever they want. Yet the person who doesn't have money will not have access to those privileges. Hence, the law is we need the law development, and which needs approach. There must be the gap has to be crossed in the legal fraternal. It also specifically emphasized that paralegals should work with disadvantaged groups to promote individual view that permits to solve their problems. This also encourages the community to be able to handle their problems and sort out their problems by their own, rather than taking to them to the maybe to the courts. So before the challenges are taken to court, they must be handled at local level. The group approach has the advantage of bringing together people with similar problems and allowing solutions to be developed with the interest of particular groups in mind. That's the problems of consumers, laborers. So this also advocates that there must be an approach that has to be guided, like whereby there must be the organizations that are going to deal with the matters according to the groups, like the consumers, laborers, tenants, and all that. There must be something like that which can be able to help in the communities. So this is what we have talked about, the two kinds of legal approach in community training. Number one, we said we said that the legal needs approach, and also we have talked about the law and development approach. So these are the two approaches that when we are as paralegal counselors, we approach the community, whereby we need to understand these theories that number one, the law is adequate. Then number two, what is the gap which is there is that people have got no access to the law. So those are the two approaches that needs to be understood. Thank you so much, and God bless you. May we meet in the next class as we continue on this paralegal as trainers.